All right, so good morning, everyone. Thank you for joining us today, July 28th, 2021, for our webinar regarding estate recovery and the probate process. I would like to begin by letting everyone know that this webinar is being recorded for later use. If you have any questions throughout the presentation, please use the Q&A or chat feature depending on the device that you're using. We'll try to answer as many questions as possible at the conclusion of the program, but we will not be answering questions during the presentation. I would also like to mention that we have created a specific website that contains many helpful links and will include the recording of this video, as well as some other resources on a specific web page. Our website for that link is www.massnala.com/estate recovery. Later in the presentation, I will go ahead and post that link in the chat for everybody if they want to click on that or use that. Again, you can also visit our website, which is www.massnala.com, and that's MASSNAELA.com. And there's a community resources tab that you can also access that website from. So our program today is being offered to supplement a 7-minute video that we produced about a month ago. That video is on that web page currently, and if you haven't had a chance to watch that, I highly recommend that you do that. And so it talks about some of the basics as far as the probate process and estate recovery. Just so everyone's on the same page, estate recovery is the process in Massachusetts where MassHealth can recover for benefits paid for certain individuals, generally over the age of 55, or people of any age that were institutionalized. So we aren't going to get into too many details today, but we are going to discuss a little bit more in depth than that 7-minute video about the probate process and the estate recovery exceptions. And we will offer an opportunity at the end of the presentation for questions and answers. So with that, I would just like to mention some of the people that are joining us today. So we are joined today by MassNALA member attorney Timothy Loff, who will provide us with a quick refresher on some of the basic content that is in the video. And if you haven't seen it, you should definitely check it out, like I said. And then after Attorney Loff's presentation, we will hear about specific legislation that may change or can change how MassHealth estate recovery works here in Massachusetts. That information will be presented by Massachusetts Law Reform Institute attorney Vicky Poulos, as well as legislative liaison for the Disability Policy Consortium, Charlie Carr. So with that, we will also be hearing about the specific legislation and sort of the legislative process from some of our legislative sponsors and their staff. So that first portion and formal portion of the presentation will last for about 30 minutes, and that will leave us for about 30 minutes of question and answers for you, our attendees. So with that, I would like to turn it over to Attorney Timothy Loff to give us a quick recap of sort of the probate process and some of the estate recovery exceptions, and just take a moment to introduce yourself. You're on mute still. Classic Zoom.
There you go. Classic. My name is Timothy Loff. I'm an elder law attorney with offices in Newton, Massachusetts. I've been doing this for a long time. I do a lot of MassHealth work. MassHealth, as you may know, is the Massachusetts form of Medicaid, which is a state and federal program that provides benefits to low-income and disabled and elderly citizens in the Commonwealth of Massachusetts. MassHealth, as a public benefits program, is required by both state and federal law to recover assets and be repaid from public benefits after someone dies. And in Massachusetts, it's limited to the probate estate that they can recover assets from. So then the next question becomes, what's the probate estate? Well, in Massachusetts, that means the estate, the assets that you own when you die that are in your individual name. So not anything that is other than individual. When we think about probate, we want to think about kind of two piles of assets. One is a pile that's your probate assets, and those are the things that are in your own name. So that could be real estate, could be a bank account, could be just about anything that is only in your name. The other pile is called non-probate assets. And those are things that can only be given out as a result of death. So that could be like a joint piece of property or a joint bank account where when you die, it automatically goes to the person whose name is a joint owner. It could include bank accounts that are called TOD, transfer on death, or payable on death bank accounts. Could include IRAs where you have a specific designated beneficiary to the IRA that gets the asset when you die. Also, investment accounts may have individual named designated beneficiaries. Life insurance almost always has a designated beneficiary. Although I will say that oftentimes what happens is that with life insurance, you name someone, let's say your spouse, you forget to change the designation after your spouse dies. It ends up being part of your probate estate because now the only person that owns it is you individually, and you haven't named a designated beneficiary. So those are the two piles, and the only pile that MassHealth can collect from is the probate estate pile. So there are some ways, obviously we've spoken of some of them, that we can avoid having MassHealth collect on those assets that you own when you die. That would include those designated beneficiaries, joint bank accounts, TODs, and also some more sophisticated legal tools like trusts and what we call life estates for real estate. So other than that, Medicaid can go after anything that you individually own when you die. Now they can recover, as Clarence mentioned, they can recover benefits paid for your long-term care in a nursing home or what we call a skilled nursing facility. MassHealth can also recover for benefits paid for community benefits you've received after age 55. A lot of people don't recognize that those community benefits can include such things as Meals on Wheels that you might get from your local aging services access point, or some kind of other benefit that you might not normally think of as being a public benefit, but in fact, it is a public benefit. If it's connected to Medicaid, if Medicaid is somehow involved in the financial process, it's going to be subject to estate recovery. And the last big one that we talk about is the idea that they can collect premiums for such things as senior care option programs, we call them SCOs, and PACE programs that provide sort of an overall activity for elderly people that they can get care in all kinds of levels. So those are the things that MassHealth can recover for. There are some exceptions to the things that MassHealth can recover for. The main exception that's just recently come into play is they no longer try and collect from a state of less than $25,000. So if all you had was a bank account and all you had was $13,000 in there, they're not going to try and collect it. They're not going to try and collect from an automobile. They're not going to try and collect personal property. But basically anything else, they would have the ability to do that. Other exceptions include, there's a caretaker child exception, which says that if you have a child that's managed to take care of you and kept you out of a nursing home for 2 years before you go into that nursing home, and a doctor is willing to certify that that child did that for you, your home can be transferred directly to the child without being a disqualifying transfer for MassHealth purposes and would avoid estate recovery. There's long-term care insurance that can provide an exception. If you have a minimum long-term care insurance that pays at least $125 a day for at least 2 years, and you have that in place at the time you go into a nursing home, Medicaid estate recovery cannot apply to your home. There's also low income beneficiaries have some ability to be kept out of Medicaid estate recovery. And also there are some delays and deferrals involved for people that have disabled children, for spouses of someone that was on MassHealth, and for children under 23, where they would put off estate recovery for a period of time in order to allow those people to get whatever they need from the probate estate during that period of time that after the person has died. So that's basically MassHealth estate recovery in a nutshell.
Great, thanks, Attorney Loff. So with that, I'm actually going to turn it over to Attorney Vicky Poulos and Legislative Liaison Charlie Carr to discuss some of the current legislation that we have at the State House and how it would change the estate recovery process here in Massachusetts. So Vicky, I'll turn it over to you.
Thank you. So I am also an attorney. I work for a Poverty Law and Policy Center, and estate recovery is really on my plate because I'm one of many people, I think, who've recognized it as a government policy that's really reinforcing poverty and inequality. And you heard what estate recovery looks like today. I am very happy to report that we have pending legislation that would change what estate recovery looks like today. And I'm going to talk about 4 key aspects of what the bill would do, and then turn it over to Charlie to talk about something specific to the Common Health program that's also in the bill. So first is just the scope of estate recovery. What can we do so that MassHealth pursues estate recovery less frequently? So as Tim said, currently state and federal law require MassHealth to pursue estate recovery for all kinds of spending after people turn age 55. Well, federal law permits that, but it does not require that. All it requires is that Medicaid agencies pursue recovery for nursing home costs, home and community-based services, and some related costs. But we have a state law on the books since 1993 saying, let's go beyond that. Let's take up this federal option to pursue estate recovery for everything we spend after someone turns this random age of 55, which is in the federal legislation. That can only be changed by legislation. The Medicaid agency, some of the hardship criteria that Tim told us about, the Medicaid agency actually improved those really recently in May, but they can't do anything about this. It's in legislation, only legislation can change it. That change alone means hundreds of thousands of people who are 55 and over just don't have to worry about estate recovery. It's not going to be required for them. Another thing about scope, and this is a change that the MassHealth agency made recently, is to say we're not going to pursue estate recovery when it's not cost effective, and it's not cost effective when it's a small estate they're defining as 25,000 or less. So that's now in the regulation. That's a good thing. We want to see it in the bill just so it's protected against later changes that may happen where an administration, an agency may want to change those rules back. That also is an important protection, and for lots of people on Medicaid, most people have very low income, very few assets, except a house. Some people have a house on Medicaid. So for lots of people, that 25,000 means I don't have to worry about this. Because as we also heard from Tim, it's complicated, and there definitely are ways to avoid probate, but often they require a lawyer. And as one client said to us, you tell me to contact a lawyer, I can't afford my rent. How can I afford a lawyer? So the first thing we want to do is limit the scope of estate recovery, which this bill will do. Many states only pursue the mandatory, not the optional. Another thing is the hardship criteria. Again, MassHealth, to give it credit, it looked at its hardship rules and found almost no one was qualifying for a hardship. And the hardship, this is for the family members who are survivors saying, we're really going to be in a pickle if we can't continue living in this house that was owned by the MassHealth member and now is in their probate estate, or if we lose all their assets. The state could say, okay, we recognize this is a hardship. We're not going to pursue it. We had very, very, very restrictive rules until May when, again, the agency, to its credit, liberalized them. We want to see that in the legislation and a little fairer process, better notice, and a better process for people who are trying to navigate this request for hardship, because we've seen family members who just get lost trying to follow the rules about how you apply for and qualify for a hardship. Then there's an issue of the amount of recovery in the case of managed care. This is a little hard to explain, but when MassHealth pays the premium to a managed care company, it's paying an average cost, and it's paying more if you're sick. That's something private insurance isn't allowed to do anymore. When you're purchasing insurance from a private insurance company, they can't charge you more because you're sick. But when MassHealth is paying a premium, it's paying a managed care company to provide services, and sick people use more services. That's my stopwatch saying I should stop talking now, and I will in a minute. So another thing this bill says is when it's managed care, you can recover up to the services that people used or the amount of the managed care premium, whichever is less. But you can't recover this fixed monthly payment that MassHealth paid to the managed care company based on your health status when it was a lot more than the value of services you used. And that makes sense as a policy because we want people to enroll in One Care and SCO. They can be great programs and not be afraid to enroll because of potential estate recovery. And finally, there's a question of notice. For many people, estate recovery was a shocker. They had no idea there was such a thing. The agency sent out 500,000 notices in May to people over age 55 or in nursing homes telling about estate recovery. Now, it was a good thing they sent that notice. That was part of the agency's effort to make reforms, but it freaked people out. What is estate recovery? How can I understand this? What's a probate estate? Is it worth it to be on MassHealth? I don't want everything I've spent my life earning, the little I've been able to put together and still qualify for MassHealth, to go back to MassHealth. I want my kids, my family to get something. And as I said, you told me to contact a lawyer. I can't afford a lawyer. So we definitely want better notice at the key points that people have a decision to make where it's important to get that notice. And now I'm going to turn it over to Charlie Carr, who I can't think of a better person to talk about the Common Health Program. He's been a disability rights pioneer in the independent living and disability rights movement for 40 years. And he's going to talk about another restriction in the scope of estate recovery specific to the Common Health Program. Take it away, Charlie.
Well, thank you, Vicki. So the legislation as it's written prohibits estate recovery for beneficiaries on Common Health. For those of you that may not know about Common Health is a category of Medicaid that allows, among other things, people with disabilities who are working age to go to work, hold down a job, and be productive members of society. There are no asset or income limitations to Common Health. So, you're not restricted to having $2,000 in the bank. You're not restricted in terms of how much you can earn. You can earn quite a nice salary and have decent assets. The way that the mechanics of the program work is that you pay a premium. It's a premium based on a sliding scale of your total family income. So every month, a Common Health member pays a premium and they continue to work. It's a wonderful program, but the notion that Vicki pointed out is that you're going to work your entire life, and then once you hit 55, everything that MassHealth spends on you is going to be taken out of your estate. And for people that are working age persons with disabilities, it's generally not long-term care, but long-term services and supports. So that would be personal care assistance, durable medical equipment, and a number of other things that health plans won't cover. So we're required under Common Health to have health plans if we can. But on top of that, we have to pay a premium for Common Health. So it has a chilling effect on people that are considering going to work. The unemployment rate in the disability community is about 35%. The disability community nationally is the largest poorest minority. So when we think about ways to get people out of poverty who have disabilities, restricting the states and federal governments, not federal government, the state's ability to go after assets collected while you were on Common Health is very beneficial. People are much more willing to go to work because they know at the end of the day, when they are ready to retire, the state isn't going to come after the assets that they've accumulated and will allow people to have intergenerational wealth. And there is nothing like that right now. It'll keep people from becoming homeless. Oftentimes, a beneficiary will die, and there's a non-family member living in the home. The Mass Health comes, forces the sale of the home, and somebody is homeless. So this is a very important provision of this legislation, long overdue. And I love this legislation because it's so intersectional. It really addresses the needs of elder and younger people with disabilities, as well as older people with disabilities. So I'll stop there.
And I neglected to mention the name of the bill, which is called A Bill to Protect the Homes of Seniors and Disabled People on Mass Health. The numbers are House 1246 and Senate 749. And I'm really honored that we have represent with our lead sponsors, who are both wonderful, Senator Joe Comerford from Western Mass and the chair of the Public Health Commission, Public Health Committee, and Representative Christine Barber from the Somerville, representing Somerville Medford on the House side. Clarence, were you going to introduce Brian, or shall I?
Sure. So I was actually just going to take one quick time out to reiterate to everybody who's watching that all of the stuff that Attorney Timothy Loft covered is the current law, and everything that Attorney Vicky Poulos and Legislative Liaison Charlie Carr covered are proposals that are part of our bills. So I just wanted to sort of reiterate that. So if you did want to rewatch part of this video or had any questions on what the current law is versus what we're hoping the law can be, just go ahead and keep that in mind. So with that, I do want to recognize Representative Christine Barber, who's able to join us. So I'm actually going to turn it over to Brian from Senator Comerford's office to sort of touch on ways that constituents can reach out to their senators and representatives to help support this bill and hopefully get it passed. And then we'll turn it over to Representative Barber to share some of her insights into the where it stands in the process and sort of what gets the legislators excited about this particular bill. So I did want to mention that, and I completely forgot what I wanted to mention. So I'm hoping it'll come back to me, Brian, but I'm going to turn it over to you for right now.
Well, terrific. Well, thank you, Clarence. Thank you, everybody. I really want to particularly appreciate Mass NALA, who has been just pursuing this aggressively, Clarence, and also Nomita Ganguly, who's also watching. Nomita's been our liaison from the legislature to Mass NALA, and you've been terrific. I also want to thank Vicky and Mass Law Reform and Charlie, who has been the really advocate on behalf of people with disabilities for so long as I can remember, and that's a long time. Charlie, you're really a hero for a lot of us, and we really appreciate it. Vicky, none of us could do our work without Vicky, who is the detail person on every single policy affecting healthcare for low-income people. We heard this very sort of explanation of how health state recovery works from Tim, and I appreciated that. And Vicky and Charlie gave some more nuance and but what we didn't hear is kind of what a politician will do. So I'm going to channel my boss, Senator Comerford, just for a second, and just say, state recovery is outrageous. It makes me angry. It makes me furious. It is just wrong in general. There's no other program where we expect people who've received benefits to then repay the program after they die. I was describing what I was doing this morning to my daughter who's visiting, and before I got a sentence out, she said, "You mean it's a loan?" And she's right. When you get Mass Health benefits and you're over age 55, in many circumstances, it's really a loan and not benefits. We don't require this for SNAP, for food benefits. We don't require this for housing benefits. We don't even require for health benefits if you have a higher income and you get, for example, Connector Care benefits. Only for these specific Mass Health benefits do you have to repay the state back. And in fact, you're not even repaying the state. Half the money that's collected goes to the federal government. So we're repaying the federal government for roughly half the cost. So Senator Comerford and Representative Barber have introduced the bills, each a bill in the House, a bill in the Senate. I'll let Representative Barber talk about the bills, but my charge is to talk about what we can do to pass those bills, which would restrict estate recovery to the very minimum that's allowed under federal law, that's required under federal law. So the bills have been referred to the committees on healthcare financing. It's a joint committee. If people listening, or you know people who happen to live in the districts of the chairs of those committees, for the Senate, it's Senator Cindy Friedman. For the House, it's Representative Lawn. Senator Friedman represents Arlington. Representative Lawn represents Newton, parts of it, parts of Waltham, parts of Watertown. You play a really special role in talking to those chairs as a constituent and asking them to move that bill forward. But even if you don't live in their districts, talking to your representative, to your senator about the bills, and what you can ask them to do is to co-sponsor the bill. So I just looked it up this morning. The Senate bill has 11 co-sponsors altogether. 6 of them are senators. So we have 6 senators publicly supporting the bills. We have 24 representatives sponsoring the House bill. So if you can meet with your representative or your senator, using the information that MassNALA has put together so beautifully, massnala.com/estate recovery, and talk to them about the bill, maybe get them to watch the short video and ask them to co-sponsor the bill. The other thing you can do is reach out to senior organizations that you know about, organizations that represent people with disabilities. And I want to just mention Letters to the Editor, which I think is a forgotten tool, but actually I would emphasize as something very important. If we organize, if we get enough support, I think this bill is doable. Given that MassHealth has sort of reduced the amount of money that they bring in from estate recovery in these regulations that took effect in May, I think it's now a relatively negligible amount of money compared to the billions that we spend for MassHealth. And I think we can just do away with it altogether. So I'll turn over to my hero, Representative Barber. Christine and I have worked together since many decades ago. She's done it all. She was a legislative staffer. That's why she's my hero, who then went on to become an advocate and then went on to become a representative herself. So we'll let Christine talk. Thank you, Representative.
Thanks, Brian. It's mutual. Worked with Brian for many years and is such an incredible, also detail person, but really good politically on these issues. So really glad to be partnering with you and with all of you on this call. Thank you so much to all at MassNALA and all of the organizations on the call. This issue was actually brought to my attention. I think I remembered it vaguely from my years of being a staffer many years ago, but when MassNALA and Vicki brought this to my attention, it is, as Brian said, a disgusting policy. It's one that makes me angry that the state actually does for people who are in need of healthcare services. And I often talk about it as being an important reason for the wealth gap. I mean, one of the reasons people in poor communities have had trouble building wealth is policies like this that can often take the family home and take any family savings that they have built up over time. And these are the kind of policies that we should be changing if we're serious about racial inequality, about addressing poverty, and about helping people acquire wealth. We know that this policy targets mainly people who have very low incomes and families that have very low incomes. So I really appreciate all of the expertise and the details. You all are amazing at that. I'm on the Healthcare Financing Committee, and as Brian said, that is where this bill is. I think the most important testimony when the bill comes up for a hearing, which it's not scheduled yet, so it'll be likely the fall when this comes up for a hearing, the stories of how this impacts families are really the most powerful thing. I think the details are important, of course, but I think the stories about this are just are really powerful and how we're going to win on this issue. And I agree with Brian. I think this is a place where we know MassHealth has moved already. They lowered the interest rate. They are paying attention to this. And this is something where I think we can win and get our bill passed. So the bill, I don't have the current sorry, the numbers in front of me. But the bill, which we can put in the chat, requires that Mass Health only do the federal minimum to pull back any assistance. So we know there's some federal laws that we can't change at the state level, but there's much more that the state could do thank you, Brian, to allow people who need healthcare to not have to pay that money back, to have their families pay that money back. Happy to take folks' questions, but overall, I'm just really so thankful for all the work of this whole group and look forward to moving this bill forward.
Thank you so much. So I just want to thank all of our panelists again for joining us today. I want to thank all of our attendees for joining. I know that the bill numbers and some of that information can be a little overwhelming at first. I just want to remind folks, and that was what I forgot, is that all of this information can be found on massnela.com/estate recovery. So we do have links to the bills. We have information about where the bills are currently at. We have links to find your legislator in case you don't know who your representative or senator are. And then we also have a link to a fact sheet. So it's sort of a one-page description that you can share or review about what the bill does and what the bill changes. So please use that as a resource. If you have questions, now is the time to sort of post those in the Q&A or the chat. So we actually had a couple, we have a few already. For you, Vicki, these are a little bit more complicated than I anticipated, but give it a shot. Try to sort of keep the answer relatively short just in case we get a few more questions. So our first question is for Vicki. Are you saying that Mass Health can only collect the lesser of the claims costs or the managed care premiums? I am asking because I see both of those listed on the all claims report I received from Mass Health. However, the letter I received with it said they will not tell us what the final cost is until the member dies. How can the family plan without accurate estate recovery cost information? And then there was a second follow-up question in regards to what the current law is versus if this would change under the proposed legislation.
Okay, I'm happy to answer those questions. I should have been clearer, as Clarence was. Everything I was describing is what is in the proposed bill that would change current law. So it's not what the current law is. And that distinction that I made in terms of managed care premiums, I think what this questioner had done, and it's something Mass Health members all have the right to do, is to submit a record request, a private record request with Mass Health and say, how much have you spent on me since age 55? And they will get back both what Mass Health paid when it was paying directly and how much it paid when it paid managed care premiums. And what our bill would say is when they're charging for the managed care premium, they really have to break it down. And during that period of time, bill you for either the value of the services that the managed care company paid on your behalf or the premium, whichever is more. What they do now is charge the full premium. So if you were in a SCO and they were paying the SCO $3,000 a month, but the only service you were getting that Medicare wasn't covering for you was Meals on Wheels, the only thing they could recover is the value of the Meals on Wheels, not $3,000 a month. But lots of people are in both fee-for-service where managed care is, where Mass Health is paying directly, and then they're in managed care. For people under who are not in the One Care and Scope programs, they'll have some services that Mass Health pays directly, like dental. They're just not included in the managed care premium. So they could, for the same period of time, they might have a premium. But this is all something for the future if this bill were to be passed. And this particular recommendation was actually made in by this federal commission called MACPAC to Congress, saying that's how managed care premiums should be recovered anyway. People shouldn't be charged the full amount of the premium, even when it's more than the value of the services they used.
Great, thank you. So our next question is a little bit of a statement and then followed up by our question here. So what seems particularly wrong to me about this issue is the complete lack of transparency and notification. Is there any recourse or way to lodge a complaint regarding this aspect? I understand a couple of lawsuits have not prevailed. Are there any class action lawsuits regarding lack of notification building? Is that a viable direction to go? So Vicki, I think you have been involved as well as Mass NALA in a amicus brief that was submitted to the appeals court in one of these cases. So if you want to describe that a little bit, I also touch upon why the sort of legislative side of things is a little bit more important.
So the case that was referred to, it actually occurred after the Mass Health member died. The Mass Health Agency submitted a claim. The personal representative of the state disputed the claim, and that's how it got into the courts. And one of the key issues really as a defense to the Mass Health estate recovery claim on behalf of the family who would otherwise inherit, in this case, it was a very modest little house, was that the Mass Health member had not been adequately notified about the existence of estate recovery at all. Or in this case, this was one of those situations where they were being charged a managed care premium for a SCO, which was thousands of dollars. And the information was that this particular individual wanted their long-term services and supports provided by a family member who lived nearby but not with them and didn't use very many services. So it was this lack of notice that was a key issue in defending against the estate recovery claim. That claim did not win in the trial court. It's on appeal in the appeals court. We're waiting for the decision of the appeals court. So the outcome of that may have an effect. I think the person who posed the question is sort of asking, what can we as Mass Health members do who have unwittingly incurred this expense that we would have avoided if we had known about it? What can we do about that? And I don't know, there are a lot of other lawyers on the call, so I'm not sure actually what can be done about that, but we are trying to change it through the bill, which would require better notice at the key points where you're deciding, do I enroll in managed care or not? I mean, in Mass Health or not, and do I enroll in managed care or not? And what are the consequences for me?
Thanks, Vicki. And one thing that I would add is that our legislation actually sort of requires more notification and transparency around estate recovery. And so what that, enacting that statute would then allow the courts to lean upon that statute if you had an individual case, or if you had a lawyer that brought that case before the court, then you would be able to point to that specific statute and say this notification requirement was not met, and therefore this estate recovery claim should not be collectible. So that's one more important reason to contact your legislators about this legislation and about sort of the estate recovery process in general if you think that it's unfair. So our next two questions are somewhat related. So the first question is, I understand that there is a 5-year reach back period for asset test. Is there any change to that? And then also, is there any legislation regarding increasing the amount of assets, the $2,000 that disabled people can have between 60 and 65, the 5-year look back period, in order to continue to qualify for Mass Health once they turn 65? So to the best of my knowledge, there isn't any legislation currently about changing those standards. But I believe, and Attorney Loff or one of our other panelists, I would look to you, but I believe that is in the federal law. So we would have to actually change that at the federal level. There's nothing that we would necessarily be able to do at the state level.
Yeah, that's correct. That the federal law requires the 5-year look back. A lot of people get concerned about that because they hear rumors about it going to 10 years or this and that and another thing. We have no evidence of that whatsoever. All we have is a 5-year look back at this point. Primarily what that 5-year look back speaks to is whether or not you are going to be able to give away assets prior to your entry, typically into a nursing home, that would cause you to be unable to be eligible because you've given away assets before you've gone in. That's typically what the 5-year look back refers to. Not aware either of any legislation involving that.
Can I just clarify too, because I think it's often confusing for people, the difference between the asset rules that pertain to eligibility for mass health and estate recovery. So there are a lot of rules. People under 65 in the community don't have an asset test at all. People 65 and over have this asset test of 2,000 in countable assets or 3,000 for a couple. And that also applies to people in nursing homes and to people who are qualifying under the home and community-based service waivers or PACE. So for a lot of people, that very low asset test is a barrier to enrolling, and there are various ways of addressing it. So that's sort of the eligibility side. That's where this whole 5-year look back. None of that really directly applies to estate recovery. Estate recovery, the Mass Health member is dead, and they're recovering correctly paid benefits. You got benefits, you were eligible for them. We knew about your assets, they were fine, you qualified, but we still want the money back. So it's different but confusing. I know a lot of people, especially the 55 and over who got the letter, said, what? You can take my house? Why didn't you tell me? You didn't even ask me about what I own, because there's no asset test for the under 65, but they're different.
So our next question here actually hits just upon that sort of 55 number. So the question is also, when you say over 55, is that for any service? For example, a healthy person who sees the doctor once per year with monthly prescriptions, is that recoverable?
Yeah, it's all services received age 55 or over with some, there is a specific exception for Medicare savings program when Mass Health pays your Part B Medicare premium, and when Mass Health picks up your share of your Medicare coinsurance deductible copay. By federal law, that those Medicaid payments are not recoverable. But otherwise, except for, we talked about they only recover from the probate estate, only if it's more than 25,000. I mean, all that applies, but that's really the difference between the optional and the mandatory estate recovery. Optional, which we have by virtue of state law, is saying if you were 55 or over and we paid for it, even though it's the exact sort of thing that private insurance pays for, nothing special, not nursing home costs, not home and community-based services, we can recover it. But that's optional, and we can change that if the legislature chooses to do so.
So our next question here is, did you say that a family can request from Mass Health how much has been spent under the PACE program for an elder?
I think I mentioned this. I actually recognized one of our questioners, and I knew she had put in a private record request. But yeah, it's you're entitled to information from your Mass Health case file, and we can maybe supply afterwards the web link, or you can just Google it. It's a private record request. There's the Mass Health section, Mass Health website explains how to make a request about how much Mass Health has spent on your care to date. Or you can say from age 55, you can say whatever. It's not going to be specifically how much will we recover for estate recovery, because they don't know that until after the Mass Health members passed away. But it can show you what was spent to date. You have the right to receive that, and people have asked for it and gotten it. So you can definitely do that. And again, there's the Mass Health, there's a section of the Mass Health website that explains how to make that request.
You know, the only caveat I would add to that is that our understanding is that there is one part-time person responsible for looking at those records and finding and giving the information back. So don't expect to happen quickly. Hopefully it will happen at some point in time, but it's not going to happen quickly.
All right, thank you so much. So our next question here brings up an interesting point. So it says, logic would follow that if a federal student loan is dischargeable upon death, the Medicaid loan, also an intangible product that can't be returned, should be discharged in the same manner. Do you know of any federal legislation that will freeze this program, perhaps as part of the healthcare package in the $4 trillion federal budget? So again, this is sort of on the federal level. We at Mass NALA have different groups working on different issues. So we do have a group that is working on home and community-based services, and they are taking a look at sort of the federal legislation, including the infrastructure bill, because it is hopeful that that infrastructure bill will also incorporate funding for home and community-based services and expanding those to help keep folks out of nursing homes, which would greatly sort of reduce the amount of estate recovery that would be out there. To the best of my knowledge, though, there is no federal legislation in regards to changing estate recovery or how estate recovery works outside of that issue paper or suggestion from MACPAC, which will also be included on our website once I have a chance to update that. So, you know, unfortunately, you know, we just, at this being a state organization and sort of state focused, we just don't have quite as much information about the federal legislation. But if you do want to follow up with me, and I think I may have forgotten the beginning of the program to introduce myself, I'm Clarence Richardson, the Executive Director of Mass NALA, which stands for the Massachusetts chapter of the National Academy of Elder Law Attorneys. So if you do want to follow up with me, my email is all over our website, but also clarence@massnala.com. And I'd be happy to reach out to some of our federal lobbyists and legislative people to see if I can find an answer for you or find out if they have more information around that. So I do not see any further questions, so we'll just give it another minute here. It looks like we might have gotten one more. How many other states, in addition to Massachusetts, collect from estate recovery in this same way? So I'll turn that over to Vicki. I know you did a little bit of research and have some interesting information around this question.
Well, since 1993, estate recovery for just the nursing home and community-based services component has been mandatory. Not all states did it in 1993. Some states didn't want to do it and sued, saying, do we have to do this? The courts have mostly said yes. So we know some states didn't even start estate recovery until, you know, in the 2000s at least. If I knew, I don't remember how many states have gone to optional estate recovery. I know some big states that went there. California made that change in 2017, and Medicaid costs in California are way more than they are in Mass Health or most other states. There are other states, a lot of states did this right after the Affordable Care Act, because I think they were struck with, now there's a new Medicaid expansion for people age 55 or over with no asset test. And there's the Obamacare, the subsidized, as Brian mentioned, the subsidized health insurance through Health Connectors. And it just seems so unjust that for slightly higher income people, there's government subsidized insurance, no estate recovery. But for this new Medicaid expansion population, there's still estate recovery. So around 2014, 2015, a bunch of states did go to optional estate recovery, but I don't off the top of my head recall the number. I also want to say I put in the chat the link for the Mass Health Personal Records Request website.
I do want to add that until these changes that happen in May, Massachusetts had the most aggressive estate recovery in the country. We were collecting more money than New York and roughly the same as California, I believe. We went way above and beyond what a lot of our peer states were doing. And, a lot of even the kind of states you would not expect, like some of the southern states, for example, were not doing expansive estate recovery. And yet here we were in Massachusetts really going after low-income people who happened to die after receiving benefits. So the new changes that MassHealth did, which I might add, I think are in partial response to our bill. I think they saw our bill coming and said, well, let's see if we can scoot by and ease some of our benefits, some of our policies, our aggressive policies, to make it a little bit easier on people. And maybe we can avoid having the bill pass. So I think all of us collectively should take some credit for the new regulations, which I think are going to reduce estate recovery by roughly about half. That's their estimate. I don't know if we agree with that or not.
Charlie, did you have something you wanted to share?
No, Brian took the words right out of my mouth. I believe that Massachusetts has the most punitive, regressive level of estate recovery, if not one of the top few.
And then I will also add that Brian did also post a link to that letter that Vicki and I had referenced to the federal government from several organizations on the federal level in regards to estate recovery. Since the federal law does have mandatory estate recovery, that would have to be changed at the federal level. So with sort of time running out, it looks like we've covered just about all of our questions. So I would like to wrap up just with a few more comments and just let everyone know and mention again, we do have a dedicated website for this information. The 2 links that were posted in the chat recently will be added to that webpage later today. And the webpage is www.naela.com/estate recovery. And that's all one word, no spaces, no dash. ESTATERECOVERY. So please visit that website if you do have further questions. On that webpage, you will be able to find our member attorneys who will be able to answer your questions. But if you are, afraid that they may be too expensive or cost too much, then I would encourage you to also to take a look at that webpage. We do have a link for some low income or no fee attorneys as well. So if you do have questions, please, please, please don't hesitate to reach out. We're always happy to help. And then I just want to encourage you one more time, please visit that website, reach out to your legislators. Without your support and without your help, we might not be able to get these changes enacted here in Massachusetts, which really, and these changes are hopefully going to benefit most of the folks viewing this, as well as folks that are lower income, and also just to provide better notification and information around the estate recovery program that may affect and probably affects someone you're related to, or at least for sure someone that you know. So I do want to thank Attorney Vicki Poulos, Attorney Timothy Loff, Legislative Liaison Charlie Carr, and Brian Rossman from Senator Comerford's office. And unfortunately, Representative Christine Barber had to step away for another hearing where she was testifying. But thank her for joining us as well, and thank all of you for joining us this morning. So if you do have questions, again, please reach out and don't hesitate or worry about a charge. If you contact me, I can put you in touch with some resources that will be able to help you. Thank you very much, everybody.
Thank you, Clarence, and thank you to everybody.
Good sign, yeah.